Good afternoon or good morning, depending on where you're joining us from today. Welcome to PwC's webinar on the New York State Department of Financial Services Cybersecurity Regulation. I'm Joe Nocera. I'll be your moderator today. I'm a partner with PwC in our financial services practice. I lead our cybersecurity practice within financial services, and I'm joined here today by Jeff Alberts. Jeff, do you want to introduce yourself?
Sure, thanks, Joe. I'm a partner at Pryor, Cashman, which is a law firm here in New York. I head up the white-collar criminal defense group, but I'm also in the financial institutions group. So I'm generally somebody who gets a call from banks and other financial institutions when their regulator is mad at them, when things go wrong. So hopefully today we can cover some of the things that can avoid that.
Great. Yeah, I've got a similar type scenario. Unfortunately, at least half the time we're helping our clients when something bad has happened. So it's good to be able to be talking about proactive steps they can take. And so we have a pretty packed agenda today. I'll just spend a quick minute giving you a sense of what's on that. But before I do that, let me cover a couple of administrative matters. With a 60-minute webinar, which we've got about 56 minutes left for, we'd recommend from a technology perspective, it's best if you close all other applications to avoid any distractions or interruptions of the video. Sound quality, we found that using headphones can be the most useful. And you can enlarge any of the slides by clicking on the X in the upper right-hand corner. You can ask questions throughout the session today. Type them in the Ask a Question box and hit send. You'll notice me checking an iPad here. That's not me getting caught up on email. That's actually me viewing the questions as they come through. So please submit those, and Jeff and I will do our best to answer them unless they're really hardball questions. Then we'll pretend like we didn't see them. So just a quick coverage of what we're going to do today. We'll take you through a quick executive summary. We'll give you a sense of the timeline, both on where we've been and where this is going over the next 12 to 18 months. We're going to really spend the majority of the time on the requirements and helping you understand those requirements, but we'll also share with you some insights of where we think there are going to be some challenges, where our clients are going to most likely struggle, or where we've already heard some questions. And then we'll leave you with some next steps, and if we have time, we'll share some leading practices. These slides will be made available after the session, and so if we don't get to a few of the last slides from a leading practices perspective, you'll have a chance to take a look at those. So with this, let's really cover the regulation itself. It really started with a proposed rule, which was released in September of 2016. And it was really a fairly significant expansion. I think I was quoted earlier this week as saying it was probably one of the most prescriptive and aggressive pieces of cybersecurity regulation that we've seen. And the final rule was published just a few short days ago, and will take effect, we were joking here before the webcast started, in less than 12 hours. It'll actually be in effect. So largely when we look at the regulation, we see it as mostly being in line with other industry-leading guidance, whether we look at the FDIC handbook, which many banks have had to comply with for quite some time, or the NIST cybersecurity framework. Much of the guidance that we see in the regulation is consistent with that. However, there are going to be some areas that we think are going to create some challenges. We're going to spend some time today trying to highlight where we see differences between this other guidance that's out there and what the rule is requiring. And we'll also give you a sense for some of the adjustments that happened, both from September through December, and then what we see coming forward. Now, as we talk about applicability, one of the questions that I get all the time is who's covered by this? You know, got clients that are headquartered in other states that do the majority of their business in other states, but they have either a sales and marketing office here in New York, or they have a branch here in New York. Maybe they're a global bank that has offices here within New York. Can you just give us a sense, Jeff, for how you think about being a covered entity, which is the language that the rule uses?
Sure. Well, Joe, at this point, we're kind of reading the tea leaves. So I think until there's been some interpretation by the agency, it won't be clear. But the starting point is the regulation itself. And the way in which it defines what's covered is who the entity is that has the license. So if an entity is required to either have a registration requirement or a license or a charter, the entity that has that licensing requirement, that should be the focus of the definition of what the covered entity is. And so in some instances, that can just be the branch, and the branch has its own branch license. In that case, the branch is really the covered entity, and that's where the focus should be on ensuring compliance. But in some instances, where you have an entity that has offices all over the United States or even all over the world, and we'll get into that more later, the entity itself is the entity that is located all over the world. And then the entire entity has to seek to be compliant. And that can create some real difficulties.
Absolutely. And again, it's not just the banks, it's the investment advisors, it's the insurance companies, health insurers, a broad range of potential financial services firms would be covered.
Yeah, I think that when this first came out, a lot of people focused on the fact that it was called the Cybersecurity Requirements for Financial Services Companies. And if they weren't financial services companies, they thought, oh, well, this doesn't have anything to do with me. But when you read through the text of the regulation, if you're subject to a licensing requirement under the insurance law or under the banking law, you're subject to these regulations, even if you're not a financial services company at all. So I think there may be some people who, in 12 hours, are going to be a little surprised that they're suddenly subject to this.
Right. So let's take you through kind of how do we get here, because one of the questions that I had from a number of my clients, really starting in the fall, was, oh my goodness, where did this come from? This is a huge set of requirements, and this is the first I'm hearing about it. Right. And I actually think the DFS kind of hinted to where they were going with a series of publications really over a number of years, starting back in 2013. Governor Cuomo actually appointed a cybersecurity advisory panel that started to look at regulation within this space. And in 2014, the DFS actually did a survey, a report on cybersecurity within the banking sector. They followed that up with a survey on cybersecurity within the insurance sector. And then they actually even focused on cybersecurity for third-party service providers. So again, you really saw this build-up, if you would, to where we are today, where, as I mentioned, the draft was published in the fall. You had a update in December, which was really a revision based upon industry feedback and comments. And then we had I'd say a minor set of updates here in February, which is really, I would say, more kind of syntactical, grammatical, a few clarifications on exclusions and the like. And as we mentioned, we're here at the compliance date, the effective date of tomorrow. And we'll spell out kind of where do we go from here, because we do think there are going to be some key milestones that are going to come up following the way. So we've talked a lot about the rule, but we haven't actually told you what's in it. What are some of those requirements? And so we wanted to spend a few minutes focused on some of these requirements. And I think there are a couple aspects of this that are most important, and we really lay them out from two perspectives. There's a set of governance requirements and then a set of technical requirements. And so let me touch a little bit on both, and then you can maybe add some color on a couple of these. I have a few questions that I've planted for you. First and foremost, the requirements from a governance perspective really require firms to take a risk-based approach to developing their cybersecurity program. There's a notion of doing a risk assessment to really inform the decisions that you make. There's a series of policies from a cybersecurity perspective, 14 specific policies that should be both created and then approved by some senior official within the firm and reviewed by the board. There's a requirement to have a designated chief information security officer, and so we'll talk a little bit about what that is. And then a whole series of requirements around education and training, third-party service providers, data retention requirements, training for staff, incident response plans, et cetera. I think one of the ones that jumped out, and Jeff, you kind of hit on it earlier, was the notion of third-party service providers and what the requirements might be around those, both for the firms themselves and then others that are service providers to financial services firms.
Right. Well, that's us. So I think because of my specific background, this was something that really jumped out at me. I'm often somebody who, when a law enforcement agency or a banking regulatory agency initiates an investigation, I'll get a call saying, we have a subpoena, we have a document request, we need to respond in 2 days, and they'll start flooding me with documentation. I will then take that documentation and I'll often send it to another vendor who helps us with electronic discovery and whatnot. And with these new regulations in place, before we got any of that information, we would have to certify that we complied with the bank's own internal requirements for how data is handled. And the service provider that we provide the data to would have to do that same certification. And it's not just the process of signing a certification, they have to actually have all of the processes in place. So one thing that's really important for financial institutions to think about is, do I have those third parties in place so that when an emergency happens and I have to take time-sensitive steps, I know I have people already there who I know I can send data to. I know they have that they have all of the authentication procedures in place, and they have procedures in place to protect all my data. Because if I don't, the regulator is going to get really mad at me that I'm not moving quickly. So it's just something to be thinking about up front before that crisis hits.
Yeah, I was struck. I know internally within PwC, our own information security program reached out to me in the fall and said, hey, help us understand this better. We want to make sure that we're doing the right things so that if customers start asking us questions about our practices, we can communicate how we're aligned with the guidance.
Sure.
I want to spend a couple minutes on the technical requirements, and we have a slide later on where we'll go into some more detail. But there were some, I think, unique technical requirements, which really raised the bar, if you will, as it related to cybersecurity. One was the notion that you had to implement multi-factor authentication for external access to the internal network. So a very prescriptive set of guidance around that, and something that, while some of our leading clients are doing today, I think some of the smaller firms are probably not doing that as consistently as they could. Sure. There was also a focus on the use of encryption, fairly prescriptive notion of encryption both at rest and in motion. And maybe a term that we should talk about a little bit, Jeff, and if you could offer a perspective on, is the notion of non-public information. So we've seen other regulation from a cybersecurity and privacy perspective that's looked at personally identifiable information and has looked at financial information, or they've looked at healthcare information, protected healthcare information. This regulation talked about the notion of non-public information. And can you give us a sense for what that means and how clients are thinking about that?
Right. I mean, there's a specific definition of non-public information that's given in the regulation, and non-public information simply means information that isn't accessible to the public. But then within that non-public information, there's this category of information that has to be subject to these protections. And I think one of the most difficult areas, there's the traditional areas of protection like healthcare information and personal identifying information, date of birth, social security number, that type of thing. And I think that's easier for banks to manage. The other category that's been identified is defined very vaguely. It's kind of using a general definition of materiality, such that if the information got out, it would have a significant adverse effect on the financial institution or the covered entity, even if it's not a financial institution. What's scary about that is it's always easy after the fact to see whether the information was the type of information that would have an adverse impact on the bank because it got out, it had an adverse impact, and then the regulator comes down and says, well, wait, that had an adverse impact, why wasn't it protected? And you're in a tough spot because if you think about it, there's all kinds of information about how the bank is managed that could have an adverse effect. The most obvious is, I guess, information that falls within traditional kind of securities fraud type cases where if the information got out, it would have a material adverse impact on the stock price. But if you think about it, there's all kinds of other information about how a bank operates, which if it gets out, also could have a bad impact on how people perceive the bank. And it's hard to predict that ahead of time. We've seen some large financial institutions recently where certain aspects of their practices got out, had a big impact on the bank, but the practices themselves were very specific. And I think it wouldn't have been obvious ahead of time until you had known that there had been missteps being taken by people that were fairly low in the organization. I don't think it would have occurred to anybody that might fall within this category of protected information. So it's something you really want to be thinking about as an institution up front, how you're going to define that and make sure that that definition will be defensible down the line if somebody asks why you defined it that way.
I think that's a great point because there are a series of technical controls that are all focused around that scoping of non-public information, and I think encryption is the one that is the most noticeable within that space, but it certainly has an impact across the board. The other technical requirement that comes out that I'd like you to spend a minute or two on, Jeff, is the notion of breach notification. So there's a variety of breach notification requirements, particularly at the state level around privacy-related notifications. This one's fairly specific in the notion of a 72-hour window anytime there's a cybersecurity event.
Right.
And a number of my clients have had questions around, wow, that's pretty aggressive. It usually takes me a while of investigating an activity before I feel like I know enough facts to begin to report it. And so can you give us a sense for how you're talking to clients about that 72-hour window?
Right. So the 72-hour, there's a certain amount of control that the entity itself has over when the 72-hour window opens. And it's because the 72-hour window is defined around when a determination is made by the entity that the breach has certain characteristics, that it happened, that it's sufficiently material, that notification is necessary. And so what's important about that is because the institution has some control over when it makes a determination, it's important to have that process of responding to news of the breach be run by somebody who appreciates the potential implications of that. So the general counsel or the head of compliance, because otherwise it's easy to have a situation in which somebody who's fairly low in the organization just types out, hey, I just figured out that we had a material breach. And once they type that out, well, that will look like a determination if after the fact anybody comes back and says, did you comply with the 72-hour deadline? So it's important for people when the information's first coming in to not be communicating in a way that suggests that final determination has been made. Because as you know, when you're responding to these things, you get new information every 10 minutes, and you can think it's a huge breach, and then 10 minutes later, you're like, oh, it turns out only one person got that information. And so you don't want to make that final determination until you have sufficient information. Once you have sufficient information, it makes sense to then kind of formally draw a line in the sand, say we've made that determination, and as long as that's defensible, I don't think anybody's going to come back after the fact and say you didn't comply with the 72-hour requirement.
So my takeaway from that, Jeff, is it's really important to have a formally documented process and criteria by the way you kind of triage and who has the ultimate authority to declare that this is indeed an event, right?
Yep.
If you're trying to make that up on the fly or do it in an ad hoc manner, it's difficult to defend your positioning, right?
Yeah, and you can have inconsistent statements being made by people. It's good to have a kind of chain of authority for making the determination up front.
Okay, great. So a couple of other areas of technical guidance before we move on. There is a requirement for penetration testing and vulnerability assessments that has to be conducted on a regular basis. There's a fairly, I'd say, more stringent requirement around the audit trail and the amount of time that firms need to be able to retain the audit trail information so that they can reconstruct any financial transactions that happened during a breach. Access privileges, the idea that you're limiting access to the minimum necessary is certainly an area of focus. And then lastly, application security practices that are reviewed and approved by the CISO on a regular basis. So we'll spend some time on which of these we see to be the most problematic, but we did want to at least give a brief summary and an overview. Advance the slides here. So I'm not going to spend a ton of time on this. I will tell you that I found that the December updates were refreshing. I think that the original guidance in September, while mostly consistent, there were a couple areas where they were problematic. Particularly, they were somewhat one-size-fits-all. They didn't really provide as much flexibility to make risk-based decisions, to look at compensating controls and other feasibility. Right. And so, if I were going to summarize the nature of the changes, generally what we saw was, a more risk-based approach, better clarification on what the NPI, the non-public information, would be, and then also clarification on some of the exclusions. Things like reinsurance and other types of affiliates, captive insurers, as an example. Right. And then I think also a softening of some of the deadlines. The encryption one, as an example, I think shifted from one version to the next, and we'll get specifically to those dates here over time. The other notion was the incident response plan. Originally, there was a requirement to test that plan. Well, that's still a good leading practice to do. It's no longer a specific requirement of the current rule. We did want to spend a little bit of time going through each of these, and I think we've touched on the vast majority of these, but I do want to spend a few minutes. So we've touched on the encryption of non-public information. We've touched on multi-factor, and we've touched on incident reporting. The one that we haven't really touched on very much, Jeff, is the notion of an annual certification. And this is really, to me, for my very large banking clients that have been FDIC regulated, they look at the majority of this and they say, I'm kind of doing this already with my existing banking regulators. This doesn't feel like much net new to me. Right. That certification requirement seems like it's very different, sure, and it's a pretty high bar. So could you spend a few minutes talking through specifically what the certification is and the way clients should think about it?
Sure. I mean, people are right to be concerned about the certification for a couple reasons. One is that a lot of times the people who are going to be making the certification, especially if it's a board of a large organization or an organization that's based outside the United States, may have limited knowledge of what's happening on the ground. The other is that, frankly, certifications are often the starting point for any enforcement action that is brought by a regulator. So it's clear that one of the the Department of Financial Services has been bringing increased number of enforcement actions recently, and the starting point for any action is a false certification. So they're clearly trying to impose some form of accountability, and that means potentially an enforcement action. So it's important for anybody who receives a certification form to make sure that they have all the information they need. Some of this can seem obvious, but it's important to kind of think through. One is that it's important that the board member or the officer that's doing the certification actually review all of the necessary documents. Yep. So that sounds obvious, but given how complex this Part 500 is, it's important that every aspect of it, he's certifying that the organization complies with every aspect of it. So it's important when they get the set of documents to make sure that they have the representations that apply to every single one of the individual requirements. So if they have all the requirements but one, their certification, there's not an adequate basis. The second is it's important to preserve the record of what they actually did review, because the way that this is going to play out is you sign a certification, something goes wrong the next year, people all come back and say, well, wait, you signed off on this. Why did you sign off on it, board member? And the board member's like, they told me they were doing everything right. And then there's a scramble to make sure that they have a record of exactly what they were told and who told them and whether it was reasonable to rely on it. So it's important to keep that record for use down the line. And if it's a board member, there's usually an automatic way that happens. All the board packets are preserved over time. But if it's an officer, it's important to put something in place that will allow you to show the regulator later on we had adequate documentation to make that certification. A related point is that it's important that all the documents be understandable to the reader. And there's two issues here. One is sometimes the people who are running this process are very technically savvy, and they can create documents that will be utterly inscrutable to a board member who maybe doesn't even own a computer. And so it's important that if down the line a regulator says, well, why did you sign off on this? What was your understanding of what was happening? The document they show is something that the person can reasonably say that they understood and explain back to the regulator. So it needs to be perhaps in a language that's less technical than the documents that are being used by the people, in the IT department or in the cybersecurity group or by the head of compliance when they're actually doing their job.
And I think you made the case even in the native language, right? Because a lot of the issues we're going to see is some of the foreign-owned banks that have, U.S. branches that are regulated in New York, making sure that it's in their native language in some cases.
We've run into that exact issue with some of our clients where if it's a domestic branch of a foreign bank, the board that actually would be signing off doesn't have a lot of native English speakers. And so a practical thing to be thinking through is if down the line the regulator says, well, why did you sign off on this? And you give them a stack of documents and it's all in a language that you can't read, the regulator's going to start thinking, maybe a penalty is appropriate here because it's obvious that you didn't make a knowing certification. The last point that I wanted to get to is that if you make a false certification, there's a potential for both a civil money penalty, and we've already seen that in analogous circumstances, though not for this regulation, obviously, yet. 12 more hours at least till we might see something like that. And so it's important to think well in advance about what documentation you're going to be preparing for the board. Because if you think about it, whether or not an institution actually did comply is a very different question from whether or not the board member defensively signed off on a certification. You could have situations both in which there was non-compliance at the bank level, but the certification was reasonable, or you could have compliance at the bank level, but an unreasonable certification. For example, if the certification was based on documents in a language they never read. And so I think most financial institutions are really focused, properly so, on that first step. But if you're not thinking at the beginning about what documentations and what certifications you're going to need to provide to the board member and wait till the last second, there's just going to be gaps, and you're going to have a situation where that board member is potentially vulnerable to a civil or criminal penalty. You don't want that.
Great. So a couple questions that have come in that I think are related to this, so I'll put them out there now. One is, how do you handle areas of non-compliance? It's presumed that some group of firms are probably not going to be 100% compliant, and so how do you capture that as part of your certification process would be the first question.
Sure. I think the important thing, there's a couple things to keep in mind when you're dealing with the DFS on this. One is, especially if you're a bank that is subject to formal supervision, you have regular contact with people at the DFS examiners, you want to apprise them ahead of time of the fact that it's likely you're not going to be compliant with all aspects of the requirements. And this just happens. You're doing your best to comply with all aspects, and you suddenly realize that there's one entity that has a special system, or you just merged with another company, and that company, you're just not going to be able to get your systems fully compliant by the deadline. Give them a heads up and discuss what form of certification that you're going to be comfortable making. And then I think it makes sense to certify those aspects of the requirements that you are compliant with. And for the ones that you're not compliant with, say that we anticipate that we won't be compliant by this deadline, but we've instituted the following steps to address that noncompliance. And this isn't the first time where some certification like this or a representation like this is being made to regulators. They understand that sometimes there's noncompliance, and I think especially in this first year, they're going to be reasonable in their interpretation of whether it's a serious violation.
And I guess the other lessons learned that I've seen from other types of efforts like this is because it's a risk-based approach that does give you some judgment calls on where you're going to apply controls and how you're going to apply them.
Right.
It's really important to capture that rationale for why you came to the conclusion that it wasn't feasible to apply encryption in this scenario, or this is how we define non-public information and a material breach, et cetera. Anything you could do to perhaps capture the rationale for how you're thinking about that and then test that with the regulator kind of on an ongoing basis so that there are no surprises, you're certainly better off.
Yep.
The second question that came in that I guess I wanted to throw over to you, Jeff, was really around who should be actually doing the certification. So you mentioned a board member. Mm-hmm. The rule seems to allow for a board member or a senior officer of the firm. We've even had questions, is it okay for the CIO to be the person that signs off, or the CISO, him or herself?
Right.
How are you advising clients around that topic?
Right. The initial instinct is to have the person who's most knowledgeable in the entity sign off on it, and that's going to generally not be the board member. It's going to be, whether it's the head of compliance or the CISO themselves. The potential downside of that is twofold. One, it kind of ratchets up the pressure on that individual, and those people are already kind of very stressed out about this. And if there's a mistake made, it's more difficult for that person to defend the mistake, because if a board member says, look, I reasonably relied on what I was provided, that has a very different meaning than if the person who's hands-on on the ground says, there's no one else they can say they reasonably relied on. So that's one factor. A related factor is what you'll see is if you have somebody who's lower down in the organization doing the certification, that can result in a kind of siloing where the board really never ends up getting the type of knowledge that they would otherwise have. And so for that reason, we've seen a lot of institutions push it to the board, both because they want to show the regulator that the board has that level of commitment and involvement, and because just institutionally, board members it's more common for them to be taking those kind of certification steps and taking that potential liability on themselves, and there's insurance in place to cover them if there's ever a question after the fact. So there's pros and cons either way, but we've seen a tendency so far to have the board members making the certification.
Certainly, I'm not the lawyer of the group, so this is a non-legal opinion, but I think from a leading practice perspective, we've talked a lot to our clients about the fact that cybersecurity isn't just a technology issue, it's really an enterprise risk issue.
Right.
And so we see it as certainly a leading practice that somebody independent of the technology organization, at a minimum, is doing that certification, whether it's a chief compliance officer, a chief risk officer, or a board member. I think personally it would be difficult to justify that you've had the right credible challenge of that first line operator if somebody in the technology function is the one that's signing off on it, just from a practical perspective.
Sure.
I did want to move on because we've gotten some questions about dates, and there are a number of, I think, key dates that we would like you to be aware of and focus on. So obviously the effective date, as we touched on, is March 1st, which is now 11 hours and 30 minutes from now, depending on where you sit. I guess we're in New York, so it would be New York time, right?
Right.
And then as you think about the going forward dates, many of them are a phase-in over a 180-day period where they would expect you to be compliant But really the first major milestone where you're going to have to demonstrate compliance is in February of 2018, specifically by February 28th. A couple key ones we'll highlight. It's expected the Chief Information Security Officer makes an annual report to the board. We would expect the contents of that report would include the results of the risk assessment that was performed, the results of any penetration testing or vulnerability assessments, the results of any other type of kind of controls maturity or state of compliance report. So those sub-bullets that you see there around the penetration testing, around the periodic risk assessment, those we would see as being a real good supporting set of materials that would support the CISO's report to the board. The other two activities that phase in on that date is the implementation of multi-factor authentication. So to the extent that it's not already in place, you'd have to have that in place by February of 2018. And then regular cybersecurity awareness training. And so again, as we think about that, we think the leading practice there isn't just to train all your employees, but also some level of training up to senior management and even the board. Part of that presentation the CISO would be doing to the board should include some level of awareness around the cybersecurity topics. And so February 2018 is the first milestone. The next major milestone that we see coming into play is August of 2018. So another 180 days out from the February deadline. The application security policies and procedures need to be in place. The audit trail for transactions that we talked about need to be in place. Your data retention policies, your employee monitoring, and then the very first milestone around encryption. So there was a question on the webcast about when does the encryption come into place, and originally it was a more aggressive date. That's been loosened a little bit so that the initial encryption deadline is August of 2018, and then the further deadline for encryption at rest stays out in 2022 actually. The last major milestone that's kind of highlighted here is third-party service provider security. So if you're a third-party service provider, it's the expectation that firms, the financial firms, will have that policy in place and they will be actively managing their third-party relationships by 2019, February 28th, 2019. So those are some key milestones to keep on board as you think about actual compliance. What this chart tries to show you is PwC's perspective really on what you should be doing first. And so we tried to break this up early over a 2-year period into a series of activities that you could do right now. In fact, you should probably be started on today. And then a series of activities that go a little bit further out and then hit on those major milestones that we talked about. And so within this diagram, you can see some of those transition periods. And so the expectation that you would be able to deliver cybersecurity training, you deploy multi-factor authentication, you'd have performed a risk assessment. The fact that you get all the way out until 2019 before you have to have your third-party management program up and running. This gives you at least our point of view and our perspective on how you think about that. I guess what I would leave you with are some of the immediate next steps. What can you be doing at the highest level? What we're really recommending is our clients start off by performing a gap assessment of where do their current practices stand in comparison to the guidance itself. And then start to develop really a roadmap for compliance. I think there was a question that came in through the webcast around, should I implement the policies or the technologies? And certainly we think there's not necessarily a requirement for net new technology in many of these areas, that you probably have existing technology in place. Sometimes there'll be additional procedures or process changes, but there may be some areas where you do need some technology. And so understanding where those areas might be would be really important. The other aspect which you started to talk about, Jeff, which I think is covered in bullet 1, is really to think through their covered entity analysis. How do you scope the portions of the organization that would be in scope as it relates to the both non-public information, and then which part of our business is actually in scope?
Sure. I think the beginning of the analysis, again, is the definition of the entity that is subject to the licensing requirement here in New York. And so that's a starting point for the analysis, is you identify the entity that has to be compliant. As a practical matter, though, you often have a situation in which the client has, there's one entity that is subject to the licensing regulation, but it's part of a much larger organization. And sometimes the organization's cybersecurity isn't based just for that one entity, it's spread out over the entire organization. And so what you need to decide, and it's important to kind of do that now, is decide whether or not what you're going to do is cordon off or make independent the cybersecurity program of that one entity, or whether or not you're going to ensure that the entire organization has a cybersecurity program that is defensible and that where the certification that is made to the New York regulator certifies that that entire organization complies with the requirement. And so, even though there's not a technical requirement that all of the organization necessarily comply, if there are parts of the organization that don't fall within the licensing requirement, if as a practical matter the organization has structured itself so that all of these different legal entities are using the same unified cybersecurity policy, then you're going to have to make that whole organization compliant. And we're seeing a lot of the most difficult decisions being made when you have organizations that are international. So especially if the parent organization is outside the United States, a lot of times they do a huge portion of the cybersecurity defense work, and their systems are very centralized and based outside the United States. And they're having to realize, we may have a year or a year and a half to become fully compliant, but it's going to take that long to disengage our system and make sure that our U.S. New York entity is completely independent, or else we're going to have to globally change our entire program. And because the first part of the timeline that you laid out can't even start until that process is complete of either creating a new cybersecurity program here in New York, or deciding that you're going to make the entire global organization compliant with the New York requirement. It's important to see that problem and make the decision immediately, because it just takes a while for these huge organizations to make those kinds of systematic changes.
Absolutely. I think to your point, it's really around, as I say to my clients, you got to follow the MPI. Where does that non-public information sit? Does it sit on systems that are in the state of New York as part of the entity, or does it sit somewhere else that's kind of a shared service for the organization? You highlighted it very well. I think you end up at a point where you ultimately have to say what's the easier or the better of the two options for us. Is it getting the entire organization compliant, or is it somehow ring fencing a component of the organization, or standing up new technology and new processes that would just allow us to focus in on New York? And so I think that's a key first step for many clients. There was a question on the webcast around the scope of penetration testing and the scope of vulnerability assessments, and I think it really touches on the topic we've just been talking about. I think the scope of those assessments needs to be risk-based, but it needs to be broad enough to cover wherever the MPI sits, right? And so if you've made the decision that the MPI is going to be sitting on a set of servers in a specific business unit, then it would be appropriate to scope your activities around that. And if you've made the decision that it's kind of commingled across the entire environment, then the scope of your penetration testing and vulnerability assessments would have to be a little bit more broad. Another question that came in, which I think is a very good one, and it really relates to point 2 on this slide around identifying the gaps between current state and future state, is what type of framework do we see for clients performing their risk assessment? And I would agree. The question itself asked about the NIST cybersecurity framework. We certainly see that as a really good guidance for building out a cybersecurity program and certainly assessing yourself against that. That being said, there are some prescriptive things in the regulation that is more prescriptive and probably goes further than the NIST cybersecurity framework does. And so while we think it's a good baseline, I wouldn't stop there. I think you have to look at the actual regulation itself, and you have to kind of take that a step further. So a couple of other items that we think are going to be critical. So once you get into May of 17, one of the areas that we believe firms need to be focused on is how do I create a process for ongoing risk assessment? So you've got the one-time kind of gap analysis and risk analysis for the way you're going to comply with the regulation and the way you're going to scope your controls. But you also have this notion that on an ongoing basis, you're going to be identifying risks, you're going to be informing management of what those risks are, and you're going to be taking action. And so beginning to think through that, we think is kind of a summertime activity, if you will.
Right.
Likewise, we think that you're going to want to engage your board and senior officers early on this. You don't want to have that first discussion be the February 28th, 2018 certification discussion. Yep. This is probably a dialogue you need to start sooner rather than later from an education. I talk about boards, they kind of go through 3 levels of cycles around cybersecurity. One is just education and awareness of like, what is the problem? Why should we care about it? What does good look like? The second interaction you typically have with the board after they've gone through that is one of like, okay, well, how do we stand? How do we stand against the regulation? How do we stand against our peers? What are we doing about it? And then finally, the third area is kind of this ongoing status reporting that then says, here's how we've gotten better. Here's where our known gaps are. Here's how we're managing the program. Are we on target?
Yeah, one reason why it's really important for the board and executives to be educated as soon as possible is because there's so much merger and acquisition activity, and every time there's a merger and acquisition, you have two entirely different systems that are going to have to be integrated. And a lot of times what I've seen is you have a situation where nobody involved in the negotiation of the potential merger is thinking even for a second about the possibility of there being inconsistent cybersecurity programs. And it can be that the people who really have the specialized knowledge who'd be necessary to assess how long it will take in order to have those merged entities be fully compliant are treated as being lower in the organization, and they're not involved in any way in the decision making, and they're not even informed that they're going to have to make the two different systems compatible until after the merger has taken place, and they're madly scrambling. So you want the people who are in the decision making position and negotiating with the other side to have in the back of their head, hey, we should call in our cyber people to talk to their cyber people and just see how hard or how difficult it's going to be. And it may be that there are steps that both organizations can start taking up front to ensure that compatibility. And if you don't have the board involved, you really it can result in this disastrous situation where you acquire another entity, the closing takes place at the end of the year, and then you're like, oh, our certification is due in 1 week, the end of the year certification. Oh, we just became non-compliant because we just acquired an entity on the last week of December for tax reasons, and we didn't realize that that tax benefit was going to create an impossibility of certifying our entire organization. And then you have to, I guess, go back to the situation we discussed before, where you call the regulator and you say, look, we can't do the full certification. We're going to certify everything but this one little new entity. And they might be understanding about it, but they might say, why didn't you think of this ahead of time? You've been negotiating this merger for 9 months, and you call us on December 29th. I'm trying to have fun with my kids. We're on holiday. Why are you calling me? So you want to get the board involved as early as possible.
There's a couple of questions from the webcast that I want to take, which I think are interesting. There's one around a client that evidently is regulated by the FDIC. They've got an exam coming up in 2018. And they're curious on whether or not the Fed will actually use the DFS guidance in doing their examination.
Right.
My perspective would be probably not, and I'd certainly welcome your legal perspective. I look at the FDIC requirements with the cybersecurity exams are largely based upon. I think that's likely to continue to be the direction that they go down. What I would say, and as we touched on in the beginning, they're largely complementary. There's significant overlap between the two, with the exception of the encryption requirements that we talked about, with the exception of the notion of doing a certification, and with the exception of some of the breach reporting 72-hour window requirements and the like. And so I would expect a federal FDIC and OCC type regulator would probably still rely on that FDIC. I don't know if you've got a perspective that's different than that.
I think that's right. The one way in which I think you may see a focus by the examiners on what's going on with respect to Part 500 is with respect to the certification requirement, because if they see what appears to be non-compliance with respect to the FDIC's requirements, they'll say, look, you certified that you complied with it, and that will potentially give them the standing to bring a books and records type violation against the entity that they otherwise couldn't, because there'll then be a false books and records entry, even though it was with respect to a different regulator that would allow whatever the OCC or the federal regulator to initiate an enforcement action or an investigation. And I'll also say, at least with respect to banks, often the examinations are joint examinations. So I've seen situations in which a federal regulator and a state regulator will either every other year, one of them will take the lead on the examination, or sometimes they'll both be present for the same examination, and they'll both be present for the same exit meeting. And so under those circumstances, you'd end up seeing a focus on Part 500 just because they'd both physically be there for the same examination period.
That's great. That's a great example. I think you touched on a point there that gets back to my discussion around, is it appropriate to have the CIO or the CISO sign the certification? I think one of the areas we have seen the federal examiners be focused on is that independence of the cybersecurity function. And so I think they would, to the extent they're looking at the certification process, and if they saw somebody signing off on it that was more of an IT type person, I could see them having concerns about the independence and the credible challenge type scenario. So that is a good one. Another question I just wanted to tick off really quickly. There's a question around what are the top 3 items that we see that's different from existing regulation, whether it's FFIEC, NIST, ISO, et cetera. I think we've kind of touched on those throughout, but just to quickly summarize, I think the 3 big ones that I would take away would be the encryption requirements, the breach notification requirements, specifically the 72-hour window, and thirdly is the certification requirement itself. And then I guess the last piece, I'll give you 4, even though you asked for 3, is the definition of non-public information is quite a bit broader than the types of information that need to be protected in the other areas. And so those would be the 4 big takeaways for me. Jeff, I don't know if you feel like I left any out.
No, I think that's right.
Okay, great. We'll keep going through the list because there's some good questions here. How do you advise your clients to start with a risk-based assessment? I'm actually going to advance the slides because we've got a good example of what we think that needs to look like. It's on slide 15 of the deck when we send it out. But this is actually the framework that we use in performing a risk assessment. It really starts around first identifying the business and IT processes that are most at risk. And in this case, I would say the ones that are in scope, if you will. So the ones that process New York business and contain non-public information. You want to really understand what those are. You want to then take a look at the threat landscape. You want to understand, based upon the information and the assets that we have, who are the most likely types of individuals to go after us. What types of tools and techniques and sophistication might they use? You'd want to look at what's happened within our industry recently. That an example I would use maybe recently is some of the DDoS attacks that we've seen target some of the UK banks. That might cause you to say, hey, that DDoS threat is bigger than what it would have been in the past. And then from there, you begin to go through this risk analysis, which is really identifying the scenarios and looking at the specific controls that you would put in place to mitigate those scenarios. And I think in this case, you want to look at the controls through the lens of the DFS guidance, right? Because you've got some very prescriptive controls that are identified in the guidance. And so you'd want to be able to document your risk rationale, either reasons why you prioritized a control lower than others, reasons why you decided that it was not feasible, or if you selected a mitigating control of some type, you want to make sure you capture that risk rationale as part of it. And then lastly, obviously, as you get through the incident response and planning process, having that good set of criteria, as Jeff talked to earlier, that really identifies, what is a material impact or breach? How do we classify that? Who has the authority to make that type of decision so it supports the notification? And so it's good when you get a question that ties directly to one of the slides that you were hoping to get to. So good to see that. Do you want to talk a little bit more about the third-party service provider requirements? One of the questions that came in from the website is, in general, what does a third party need to be concerned with?
So I think the main thing to keep in mind is whether when a financial institution is initially drafting its policy with respect to third parties, there will be an inclination to just say it's going to comply with all the same requirements we have. So they're going to do, all the authentication requirements, and they're going to ring fence all of these specific categories of data, and they'll have different policies for whether data is at rest or not at rest, and that sounds easy, but the fact is, all of these, you have to think about all of the different third parties that you use. And so, whether it's a law firm, I think law firms will probably tend to be fairly sophisticated in their compliance with this, but not always. You may use law firms that are, just do your labor and employment issues, and they're a general labor and employment boutique, and that's all they do. They have one banking client. They may have never had anybody go to them and ask them to do this. And so you'll want to reach out to them early on and say, look, we have to make sure that you have these minimal requirements. And I think it's important to realize that the policy that you adopt as a bank shouldn't be as restrictive, because you need to anticipate that some of the third parties who are going to be providing services to you it isn't going to be realistic that you're going to, require these authentication requirements that some of your service providers never will have implemented. And so you want to have a policy that's flexible, and you want to reach out to all of the different categories of third parties and make sure that they have a reasonable way to handle the data that they have. And that may be that you, as a bank, just decide we're going to change certain service providers, or we're going to adopt a policy about whether we ever send them any of the protected categories of information. We may have some service providers where we just have to say, we're never going to provide you with these categories of information because we don't think you can possibly adopt a defensible policy, but we think you can still provide us with adequate service for this narrow area that we need.
Okay, great. I did want to spend a little bit of time because I think it builds off the question that we just had. We have this notion of not doing DFS 500 in a vacuum. We've already talked about and highlighted some of the commonalities with the FDIC requirements and with the NIST cybersecurity framework requirements. But I think another one I wanted to highlight or maybe spend some time on is the DFS 504 requirement, which is really around anti-money laundering. There seems like there could be an opportunity to perhaps leverage some of what firms are already doing within that space today. Can you maybe speak to that a little bit and what you've seen?
Sure. Because one of the main focuses that I've had is on advising boards with respect to these two different requirements, they're very focused on the certification requirement. So in a lot of instances, you'll have very different people within our organization leading the charge on the ground, on the compliance with cybersecurity versus the compliance with anti-money laundering. But I think it makes sense to have them both reporting up to some one individual within the management of the financial institution, and it going from that one individual to the board. So that individual, when they're developing the board packets that contain all of the informations on which those board members can base their certification, will be thinking through things like, I want to make sure that this packet is understandable to the board, is translated into the language of the board members if that's necessary. And it includes not just the policy documentation, but it includes any certifications that have to go with that policy information. So it's not sufficient, for example, to provide the board member with a policy statement saying we will comply with this specific filtering AML requirement. Say you need to also, if the filtering service is being provided by some third party, you need to have a certification from the third party that is provided to the board member saying we actually implemented that policy. And somebody needs to be thinking about, what do I need a certification for? What do I need when will a representation be adequate? And who are all the people that I need to get those certifications from so that I can provide it to the board in one packet that they can rely on.
Okay. That's great. And just scrolling through to see if there are any final questions on the webcast itself. If we could go up to the top of the screen, Jeff. Thanks. Wanted to make sure that we tied off. There was a question specifically around, do we expect the DFS to publish specific requirements around the algorithms or key length? I have not seen anything specific to that. I would presume you could reach out and you could ask whatever relationship you have with your regulator around that topic, but I've not seen any specific guidance that would give me one way or the other unless you have that.
Yeah, and that sounds like one of those categories where I have a lot of banks that they wish the regulator would tell them what they need to do in order to comply with the regulation, and the regulators tend to not do it. They say, right, we want you to be reasonable and adequate, and then they kind of leave it to the bank. And I think that's a good example, especially because the adequacy of key length could change from year to year depending on what's going on with respect to the bad guys.
Yeah, I think there's this fundamental debate that we see in the industry between, folks saying, we don't want you to be overly prescriptive because the threat landscape changes.
Right.
And then the regulator tries to be higher level. And everybody says, wait, now I don't understand what good looks like, right?
Yeah.
And so there's this fine balancing act that I think every regulator has to go through. And I think we're all trying to find the right balance. I'm certainly of the belief that given the nature of how quickly the threat landscape changes, right? It's the notion of if I build an 8-foot wall for the castle, the bad guy brings a 10-foot ladder, and then I build a 12-foot wall, and the bad guy brings a 14-foot ladder, and so there's this constant going on. And I think it's really, and one of the things I like about the revision that happened in December, more risk-based, being really focused on what's the likely threat, and then what's the best control to get to that specific threat. We've got a few minutes left. I think two other questions I want to make sure we cover. One is there's a question that if non-public information sits on a file share where the access to that file share is controlled, do we still need to encrypt it? And my interpretation of the guidance, and Jeff, correct me if I'm wrong, I believe you do, because there are separate and distinct requirements around access control and encryption of data at rest. And my read of the documentation would be, if it's NPI and it's at rest, it should be encrypted unless it's technically infeasible to do.
Right. I think that's
And so I think to that question, one of the things that's going to come up is, at some point, does it just become easier to use encryption, disk level encryption of a SAN or of a file storage scenario, not getting into a scenario where I've got an inventory and say this is NPI and this isn't. Let's just take everything that's on that file share and let's just encrypt it at the SAN level as a technical potential solution. There was another question around the 180 days compliance deadline. So from March 1st, tomorrow, there's a 180 day out where many of the requirements in the law need to be in effect, but we don't actually certify compliance until February of 2018.
Right.
And the way I would think about that, and the way I read it, and welcome your perspective, Jeff, is that for those items that are spelled out in that 180-day window, the expectation is that you are done with your remediation, and those are in place and operating effectively as of that 180-day window, which I think is August, if my math is right. But you won't actually have to certify and document compliance to that until February of 2018.
Yeah, that's my understanding.
So I guess one final question here as we look at time. Can we talk a little bit about the NYDFS rules and NIST and regional and global activities? And I guess the slide that we still have up is probably a good example of that. Fundamentally, we see significant overlap between all these, and we think the notion of NIST and other international standards, they start around a couple of topics. The ability to identify what assets are critical, and then the ability to select a series of controls that are preventative, detective, and response related to when bad things happen. That, to me, is just good risk management, good cybersecurity in any realm. And I think if you take a risk-based approach that takes those fundamental principles, you're going to be 80% there regardless of what regulation you need to comply with. And then it's up to you to look at the specific regulations that you're subject to, both geographically and industry-based, and say, what's the net new that I have to do on top of basic good risk management? And that's the way I would think about that question. So with that, we are going to go ahead and wrap up. Jeff, thank you very much. Your insight has been invaluable. I get a lot of questions, and I'm not a lawyer, and so it's great to have a lawyer here that can keep me honest. And I thank everybody in the audience for joining today. These questions were very helpful, and have a great day.